So we're just getting started here uh, for the special action update. Um, Let me just go and check to see how the live stream is doing. Oh, that is this page. So it's doing just fine. So I have some news. As most people know, on the 13th of this month, August 2026, Judge Metcalf denied my motion for a personal recording device based on the appearance of justice standard in the court. And some of my reasoning in there was basically that, the cat's out of the bag. All you have to do is search Lane Myers' victim name, and AI comes up with the answer, at least on Google AI mode. DuckDuckGo doesn't seem to do that, but it also doesn't seem to be anywhere as interconnected as AI mode is. In fact, that's why they created Google AI mode, was to empower AI in just the search context. So they have special access to the database and stuff, and they feed context with that. And that's part of the process. I mean, you have different levels of the court. So you have the district court or the trial court, the lower courts, however you want to look at it. And this is modified if it's in the state court or city court. So in Arizona, you have limited jurisdiction courts. Those are the justice of the peace and the city courts. When you appeal those decisions, you go to the superior court, which is the trial court level on like felonies and anything over $10,000, stuff like that. From there, you go to a division of the Court of Appeals for Arizona, and after the Court of Appeals, you go to the Arizona Supreme Court. And if you really want to push the issue, from there you go to the United States Supreme Court. So, based on the case activity, hey, what's up, Plummet? Based on the court activity, this is the case number. So it is 2CA-SA 2026-0068. Jason Adam Jensen versus the state of Arizona. And it has my name on it because I'm the petitioner. And the state of Arizona is ultimately the respondent. Lane Myers is a real party in interest, along with 3 judges. That would be Metcalf, Griffin, I think I'm pronouncing that right. And then we have, and I'm never going to get this right until I hear it, Lowski, something like that. And that is the presiding judge over the entire Pima County Superior Court district. So if I go to my actual petition for special action, and this is it. It's 141 pages, but it also has exhibits, which is in the appendix. And here's the judge that is presiding over Superior Court, and that's Danielle, and help me out here, Lewowski. I'm sorry if I'm getting that wrong. And this notice right here is based on the fact that I couldn't really find any examples of how to do a special action now that the rules have changed. With the special action. So prior to 2025, the judges would have been a respondent. Now, this judge is the only respondent because it's covering an administrative action. Here's the table of contents, and so it has a request for expedited consideration, and that is because the next hearing is set for September 14th at 11 a.m. It doesn't say that, but I'm pretty sure that's right. And then we go into the introduction. So, petitioner, me, is a non-party member of the public, and I petitioned the court for special action relief, and that is because as a participant or a non-party observer participant in the court, I have been denied access for the last two hearings on being able to use a personal recording device. So it says that, and then it covers Lewowski, which is joined in her capacity of presiding judge. And I'm basically trying to get at Administrative Order 2024-47. And that is the one that says in the hallways in the courthouse you can't record because safety and security. And then we have Judge Griffin, and he is the one that denied my motion for leave to participate as public interest amicus or interventory. And so I was trying to intervene because the facts of this case demonstrate that the appearance of justice isn't met here. And I get into that later. So this is just a jurisdictional statement. I'm going to gloss over this. Because doesn't really have any bulk of the argument. It's just setting up jurisdiction. There is some argument here, but the bulk of it is below. And this basically sets up that, Hunter was recently decided, I think in June of June 18th, 2026. And so, part of what that ruling was, fair to all who observe them. And they made that part of due process. So it's interesting. And traditionally, courts have basically ruled that there's no way to intervene in a criminal matter which you're not a party to because you have no interest in it. I fundamentally disagree with that because when they make these rulings, they affect people, and then like the lowest common denominator gets to set the precedence versus the highest common denominator. And what I mean by that is poor people charged with crimes can go through the system and set a precedent, but it's all their resources to hire an attorney against the state's resources to spend whatever they want. Like in this case, they're spending quite a bit of money to put Lane Myers into a box. Lusky. Huh. That might be how you pronounce it. I'm not sure. And so, first of all, this has joiners built into it. The Hunter arguments are probably the most remote. I mean, the court's gonna like that at a rate of 1 in 100,000. The arguments against the administrator order is probably got 1 in 10,000 or something, because interestingly enough, the appellate court did the same thing as the Pima County Superior Court I mean, even if you go into the document section and you're just looking at a computer screen, you pull up the document, by the rules of the court, you can't photograph the screen, even though you can hit print and pay 50 cents a page. And they don't really review that document. So it's an interesting prospect to go to one court that has already decided the same and say that one administrative order exceeds the authority delegated by the Supreme Court administrative order. And I also have a petition to the Supreme Court, whereas people would be able to approach administrative orders that affect them and their rights without any consideration or process. I believe the court's probably having some issues with that because the court sits in different mannerisms, but at the same time, challenge. So I haven't seen an order on this. Oh, here we go. There was one. Oh, I guess I like to click on shit. Oh, we'll just keep on downloading it then. There we go. Ocular. Article. Adopt new rule. Blah blah. Statement of the problem. Result. Monetary. Oh no, this ain't the order. Yeah, so they didn't attach the order. That was my petition. Sorry, I was going through it really quick, but I mean, you can just go read it. You know what I mean? Like, you could seriously just go read it on that one. This going live isn't necessarily about that. So I petition the Supreme Court and say there's really no due process. You're using administrative orders to control people that use the court, but then they have no way of interacting with that process. And normally, when you file that, um, you you get a judicial order setting the time frames. And so at this time, I don't think the court has ruled. So they just moved it here because it's the rules of the court, Supreme Court. It's not like a civil rule. It's, um, anyways, that's where that sits. Um, but while that takes like a year or more to process, this special action includes the same problem, seeking relief. And then finally, we have the Rule 122 motion applied by Judge Metcalf, and basically, he said it was already decided when I spoke to him. I wasn't at the hearing for the media requests. And in the minute entry, all it says is, well, I have that. Um, I mean, all it says is, court denies the media request to have cameras, video, or audio recordings of the hearings for the defendant's motion to modify conditions of probation and the violation hearing. The court indicates was made possible. Counsel argues the court in his receipt. Resnick raises. Is ordered. Blah blah blah. So, my point is the rule says that there has to be some sort of finding, and there might be in the transcript that I can't afford, that no one can afford. But insofar as I can find in this order, there's absolutely nothing that, okay, for reasons as set forth on the record. Well, that doesn't mean anything. And more importantly, it's all based off of a media request. I'm not media. I'm a petitioner to the Supreme Court of Arizona to change the rules about recording. You have Matt Walker's petition that was superseded by the Arizona Supreme Court Task Force, their petition. And then that one wants to make limiting it easier and create an idea that artificial intelligence use also has to get approval or something like that. I'm not sure they really thought that one out too much. Because, I mean, copying and pasting stuff in the Google search now implies AI rules. So that was my reasoning for going to the court. And then we had really cool news call me out. So since I'm in the public, I might as well be in the public. And so the statement of facts is that basically the petition to revoke defendant's probation. Petitioner is a non-party member of the public, including session. Public docket reflects that the defendant was convicted by a guilty plea of one count of stalking, and that, I guess, is just split out into one of the cases. Petitioner filed non-party request described above seeking confirmation that petitioner may use a personal audio recorder under Rule 122H, and in the alternative, maybe I can record video. And my request was grounded in the Arizona Constitution and the appearance of justice standard articulated in Office v. United States, and expressly disclaimed any reliance on the First Amendment. On August 13, that request was denied. And basically, I can't afford and don't have the transcript. I also wouldn't have time to wait for it to be made. And definitely couldn't afford the expedition on it. So, I now will actually get the transcript because they waived the fees. Well, that actually all depends, I think. But they waived the fees, so if a transcript is ordered, that would be included, I believe. Anyway, so they denied the request. Not only was I not allowed to record or take notes with my phone and its recording capabilities, but at one point I got yelled at that I even had the phone out at all. So, I mean, I guess they would have just assumed it was off in my pocket, which it was. But, I mean, it could have been in my pocket recording, which it wasn't. But, I mean, taking it out doesn't really change anything. It was like this paranoia expressing itself through the court and its agents. And so basically, they had already ruled on the audio recording, and that ruling stood. And he didn't even really explain it or anything. He just denied. And it references the actual file. And the audio recordings... and I didn't even get the new minute entry for the two new hearings. I don't know that any of that really necessarily matters. The court indicated that the audio recording would be disruptive. I'm not going to read all this verbatim. You can pause it, or, I mean, I can upload this file to Google Drive and provide a link or something. It's not secret. It's part of it's filed with the District 2 of the appeals. So anybody can get it. So this lays down the factual pattern, which is what it's called. Statement of facts. Then we got Judy, you got this, which last time I started talking about Judy, you got this. They are they got real confrontational in the chat, like, oh, well, you know, it's just you know, you're making a mountain out of a molehill kind of thing. Well, who actually did that first? Who reported stuff without confirming it? Who made up a story about how I was trying to argue with her? I was trying to talk to her, but she started talking to me first. And then, you know, I asked her if she wanted to continue. So, and then the whole idea that I tried to get in the elevator, I mean... Talk about mountain out of a molehill, you know, but that kind of stuff can be really damaging. The implication of trying and then to get into like an enclosed space with, you know, an old woman, you know, the implications, and I mean, that's really crappy of them to do. But what I point out here is that not only did that happen, but because I wasn't able to make a recording, I don't have any proof of what happened, how it happened, and when it happened. I have my recollection, Judy has hers with her written down notes. Which you might say hers are more reliable because they're written down, but I don't know if that's necessarily the case. And I would argue it's not in this case. So I would have a record, and that wasn't allowed. And, I had to publish my own public statement, just for attending the court hearing to be an observer. Somehow I got caught up in the news. And, that's part of it. Like, I use recordings to protect myself and defend myself a lot. And people say, well, they can make up stories about anybody. Well, there's animosity towards my class, and I'm not going to get into it all. But, you know, like all the stuff that happens when somebody's talking to the wall on a bus. I don't do that ordinarily. But, the idea that they're scary and dangerous and all that, it purports itself around. And, like, I am autistic, and people do figure it out right away. And she was trying to make me out to be a creep and blah, 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 blah. So, that happened, and that is a foundation of, why the recording and the rule in the courthouse, is discriminatory. And, testified as a witness during the August 13th session. The substance of that testimony, as I understood it, Walker's own observations of online content. A subject petitioner does not understand to bear on whether the defendant's conduct violated a specific identified condition of probation, as opposed to conduct any member of the public who watched the same content could equally describe. And that's true. Like, and then it doesn't really matter. Like, I can pull up any video and start playing it, and the publication date will be today. And that doesn't mean that the video on the screen and the things being said are occurring right now. Now, maybe you can look on the screen and figure it out. Maybe you can't, depending on how it was produced. So I go into that, and then I go into my motion for leave to participate. So this is still all the factual background. And again, you can pause this and look at it. But it really has nothing to do with the arguments. So the issues presented, whether the Superior Court abused its discretion or failed to comply with a mandatory duty under Rule 122D1 by denying petitioner's request without the specific on-the-records findings the rule requires, whether the Superior Court erred by denying Rule 122H, personal audio recorder notice by reference to a prior ruling. Whether the court's stated rationale that an audio recording could be disruptive, in a sense untethered to the disruption of the proceeding itself, and that the presence of the victim justifies denial, rests on grounds of 122D1 does not authorize a court to consider, and which, if generally applied, would eliminate Rule 122H notice only right in every case involving a victim. And that's true. I mean, if all you have to do is say there's a victim and people are publishing information about this case, then that's everything except for, I want to say drugs, mostly, but sometimes even there's a victim. Whether Pima County Administrative Order blah 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 and the courthouse signage implementing it exceeds the authority delegated by the Supreme Court and are inconsistent with Rule 122 insofar as they are applied or are described to the public and court personnel applying an advanced judicial permission requirement to petitioner's use of a personal recording device to document his own interactions with court staff and others within the courthouse. Whether denial of Petition 122's H request without consideration of petitioner's individualized disability-related need for independent contemporaries record is consistent with Title II of the Americans with Disabilities Act requirement that public entities provide reasonable modifications. Whether the cumulative pattern presented in this matter, denial of petitioner's prior motion to participate, denial of petitioner's 122H request, a county-wide administrative practice, a charging theory with demonstrated chilling effect on news gathering and public accountability generally, and review available only through inaccessible special action process is ripe for this court's consideration under institutional fairness principles recognized in Hunter v. United States, and if so, whether that pattern independently supports the relief requested. Whether July 6th order by judge denying motion for leave should be vacated and remanded for reconsideration, where that order addressed only the procedural availability of amicus and administrative convenience without addressing the appearance of justice and institutional fairness theory on which the motion was substantially grounded. So now we get into the argument. And the argument is the denial lacks specific on the record findings for Rule 122D1. And it has to be that way because not only, if you look at whatever was said, and I don't know, but he denied it based on the media. And so basically he sealed the case, but only limited to the audio of the case. And I'm pretty sure I get into all that. But, and I'm not going to read all this. I just wanted to give a general update. I mean, if you want to pause it and read any part of that. And here's where I talk about it under Rule 9.3b. And I probably screwed that up because the way they do rules in Arizona, like, the only place you can find it is Westlaw. Nope, I actually got the rule right. But maybe they changed it since then. I mean, I don't know that Westlaw is actually authoritative on the rules of the court. I know you can't find anything on the Supreme Court website worth it. And that's usually where you find the rules. So I don't know why Westlaw seems to be the best source. And so that's what I'm saying. Like that, you can go there and spectate it, but you can't record it. That means the standard couldn't have possibly been met. They literally just want to control like the actual words, and I get into how uh, basically because of this, like you can't write notes fast as people can talk, and the court can advance, right? So like that's why court reporters use that stenograph machine is because you have to take shortcuts to keep up. And I think I argue some of that. Like I said, I'm not going to read all this. Um, but I mean, you can definitely pause it and read it as you care to. Um, and I'm not. I guess I'm media now, but kicking and screaming. I mean, I just look at getting involved at all, and I don't even know if I was involved with this case. I mean, I basically was like, do you want to reconsider what's going on in this case because it's horrible on every side. But I mean, the court is institutionally required to consider what the appearance of justice is, and it's not. I don't think that it's done that. I don't think there's a foundation because I mean the state alleged that there's no proper purpose or no legitimate purpose for what Lane Myers did. But what my argument is, every news story ever, somebody is in a scandal, and the first thing they do is talk to their neighbors, their spouse, all of that stuff. Um, and so that's in here, especially since, I mean, if all I have to give is notice, I mean, in what methodology did the court restrict my phone from recording? And I mean, from there, I don't know that they could restrict live broadcasting, but that would be a total separate issue. So you might be able to record for personal notes, and that would be one order. And of course, the judge is so paranoid, I guess, that he's just assuming nobody's going to follow his orders, which, if that's the case, I don't know why he's even writing orders if he's assuming nobody's going to follow them. And I mean, there have been people in his court that don't follow his orders, but is it that is this matter that serious? I don't think it is. So we go on, and in any event, this goes on the separation between my petition to the Supreme Court. Basically, I'm just complaining about the same things. Like I said, I don't see where the personal recording device was restricted by the rules. I mean, the court itself has a wide latitude in, the conduct of the court, but and the decorum, but they're not saying that me recording the hearing is going to disrupt the proceedings. They're saying that it's going to harass the victim, I think. And again, I would have to have the transcripts that I can't afford. A rule requiring on-the-record findings serves no purpose if the record so referenced is unavailable to the very parties who writes the finding forecloses. And that's what I mean by that order of the minute entry. I mean, how much harder would it be to put on the record findings in the minute entry? And at least then I could argue why it's wrong, which I did anyways. No fee, no filing, no finding, notice alone. And that's where we're saying. Rule 122H. And the Supreme Court kind of implied what I'm saying here is, if you're just going to privately record the audio in a public hearing, there is no objection that the court can take. It's supposed to be open. So I go on and on about that apparently. And so then I get into the costs. $6 per page plus 20% transaction fee. So, I mean, I have no idea how many pages, but, we estimated 320 pages, which would come out to $3,840. I don't have that. I don't know anybody that does have that, just to observe what the court is doing. And so then I talk about how absurd it is that we're using individual recollection of what happened. Okay, so then the stated rationale rests on grounds outside Rule 122D1's enumerated factors, and if generally applied, would nullify the rule. To the extent that the Supreme Court's oral explanation supplements the minute entry, Superior Court's explanation given that recording could be disruptive in the sense extending outside the courtroom, and the presence of a victim justifies denial, does not correspond to the rule. And then, I mean, it would basically, I can't think of a case that would allow for recording at this point. And then I go on, I mean, I go on about how the plea deal was structured and how all these charges were dismissed, in that plea deal. And then, stalking is an aggregate or a bucket offense or whatever you want to call it. It's not just a course of conduct, but it's a repeated course of conduct. So, I mean, having harassment on there 6 times makes no sense. It's all harassment. It's all the same course of conduct. And I'm pretty sure I get into that. And again, I'm not representing Lane Myers. I'm talking about the appearance of justice and the, chilling effect on free speech with this case represents. I mean, for all I know, they're coming for me because I've been reporting and I've said, Matt Walker's name, and I don't know how to report the shit any other way. The dude that is, in a relationship with the victim, but I mean, he did more than that. He filed, and as I get into in this, he filed stuff. Like I said, I'm not gonna read all this. The state's and this should be interesting. So, what I'm talking about here is, the court can protect the victim up until she starts trying to give like an impact statement and influencing the court's decision. And so, like, let's say a victim gives an impact statement, and based on that, the court increases the penalty. Instead of 6 months, makes it a year of prison time. Well, that all has to be on the record and stuff, and that is all part of the appearance of justice standard. And then I talk about, me being accused of things, and because I don't have a recording, there's no evidence of what actually happened. So somehow in the court, it's a he said, she said. Blah blah blah. You guys can read this, and that's exactly why I record stuff. Americans with Disabilities Act, and blah blah blah. Oh, there's my autism and social stigma. The information any privacy-based rationale would purport to protect is, on this record, already comprehensively public, foreclosing the compelling interest narrow tailoring, showing Ridenor requires. So, Article 2, Section 11 of the Arizona Constitution requires justice in all cases shall be administered openly. And I gotta say, what a miserable... What did that one guy say? I ramble and am not on point. But what a miserable experience. I know Judy, you got this, complained about the benches. And I later moved over to, the really nice office chairs after I asked them, and they let me move there. But what a miserable experience. I mean, from 9 in the morning until 4:30 p.m., you're going to sit on a wooden board, not move, not talk, be quiet, in theory, ideally. And, there's no cushions or nothing. I noticed on the second day, Judy brought a cushion, and that was probably the most genius I've seen out of her yet. But I like my upgraded chair option better. It leaned back and all that. But what a miserable experience, They talk about the court has to be observed openly. And, so let's just make sure nobody shows up because they don't want sores from sitting on the bench. And this goes on, about that standard, the cases about that, cases that have already been decided. The court explained that because of a widely disseminated previous recording on the case and readily available public records, the court's order likely had no real effect except to temporarily limit the media in reporting on the trial, since the prosecutor's name had already been associated with the case in numerous media accounts. So that case was Phoenix Newspapers versus Otis, and that was in Division 1. And it's talking about how, for some reason, basically the same logic in the Myers case. They're limiting the audio, and there's no reason for it because the order can't achieve what it aims to. I mean, the information is already out there. As to the personal audio recorder specifically, Rule 122H leaves the Superior Court no discretion to deny on any ground direct relief, not remand is the appropriate remedy. So basically, this is what everybody else has been saying, I think. 122H doesn't really allow for anything but a notice requirement, and that is because if you haven't excluded the observers or the participants and you haven't sealed the case and the case is public record, then there's no reason to not allow a passive audio recording device. And that's basically what's incorporated in the rules. Blah, blah, blah. And, I mean, the standard is the one Reindor and Schwartz supplies, a compelling government interest and narrow tailing to serve it, established by specific findings. And there's a big point there, the narrowly tailoring. I mean, there's nothing the court can do to protect this woman's identity, and not because it couldn't have in any case, but in this specific case, because the elements of harassment that Myers was charged with is based on using YouTube. So before the case was ever even filed, all of this stuff was already out there. I mean, now they had Lane remove the videos, but I mean, we saw how ridiculous that is. I mean, there's like 5 other channels now that uploaded all that crap to a different channel that he doesn't control. And I mean, it's not permitted, but I will say that there's tools to download a YouTube video. It's not rocket science. I mean, there's usually just websites that make you watch a video or something. Ads. So it's unsealed. So again, there's no reason for it. It's not a compelling interest, and it can't serve that compelling interest if there was one. And again, a lot of this is on the appearance standard, which is way different than even like contract enforcements. I don't have to prove anything in the appearance standard. All I have to do is show, hey, this is what it looks like, and boy, does that look bad. So I'm going to skip by some of this. I'm going to pause a little bit so you can read it if you want to. So again, I point out that, they made this case part of the petition to the Supreme Court, and instead of flipping out and calling APAAC or that other, the task force and demanding public records and all that, I missed the window. So I just filed my own competing petition, There you go. And there we have it. There was no reason to do all that other stuff. And I talk about that. And that administrative order, I'll get to that. It's in this document as a part of the appendix. But it actually says that you can be charged for disorderly conduct. You can get charged for harassment. Like, how it. Ignore everything else with the administrative order here. But how is it that if I go into a courthouse and ignore that rule and take a picture of, say, the sign that says it's a rule, how would that be disorderly conduct or harassment? Like, I mean, and then, the same judge that oversees the administrative order, you're now going to go to court in that same jurisdiction. So, how do you get a fair trial if the administrative order has already said that it could violate these crimes? I mean, that administrative order has a lot of problems, in my opinion. Um, and so we go over the rules and the administrative order, and we compare basically, inside is 122, inside the courtroom is 122, outside the courtroom but inside the courthouse is an administrative order, which again is just wicked because I mean, how does an administrative order deal with me? Like general orders and administrative orders, the rules are supposed to go through a process. So if you're going to make a rule, you should just make a rule. And they might be trying to say that administrative order has to do with stuff outside the scope of a court case. But that's my whole point. Because it's an administrative order, there's no process for me to complain about it, get an exception, get it modified, whatsoever. So again, I'm going to scroll through some of this. I don't want this video to be 100 years or long, and it's already I don't know, it doesn't really say. It's already 56 minutes long, and I am probably halfway through it. So you guys can read this if you want to. It's just more about the separation between 122 originating from the Supreme Court. Then you have the administrative order at the Supreme Court, which delegates authority to the lower courts. And then you have the Superior Court using the administrative order of the Supreme Court to then make its own administrative order. And ridiculously enough, taking photos somehow implies the safety and security of the court. I'm sorry, that seems way out of the whole purpose of safety and security. So we go on and on that. Both of petitioners' efforts bring outside scrutiny to this matter, invoked by identical appearance of standard on their face, and were both denied without that standard ever being engaged. And that is interesting. And Hunter is new, and so I filed that like weeks after Hunter. So I read that case and was like, how does it apply to this stuff? And I go on and on about Hunter and the appearance standard, and I try to explain it. The timing. So, Hunter was decided June 8th. Of course, the Arizona courts haven't had time to adapt to what it says. If it says anything for them. Some people have argued since it was a federal case, it has no bearing on state stuff, and I seriously think you haven't read anything about the appearance standard if you're going to say that. Plus, they applied it to due process rights, so it definitely covers the state. I'm again going to skip through some of this. You can read the details, and it's very similar. You have Hunter, who was charged, pled guilty, got a plea deal, signed a plea waiver, a whole 9 yards, and then they ordered him to take drugs, any drugs the psychiatrist they assigned told him to take. He just had to take it, which you might be thinking, oh, well, that might make sense. It was an embezzlement case. Yeah, he had a history of mental illness, but what does any of that have to do with dangerousness to self or others when he embezzled some money? Which is the standard to order somebody force medicate. So we compare the case, and in this we talk about the 20 counts, 14 counts in the first case, and 6 additional counts in the second. The amount of time that could be, but we also talk about how expensive that case would be. I mean, lawyers like to charge a couple $1,000s per misdemeanor, and like, $7 to $10 or something for a felony. And so if you got 20 of them, you're looking at a house just to be innocent and keep your freedom. And that involves the appearance standard. We're going on and on about the appearance standard here. And then we talk about ARS 132921A's no legitimate purpose, which is supposed to be the constitutional floor. But, of course, none of that gets talked about. And it never got tested because they forced a plea deal. And, y'all can say anything you want, but they could have charged this one case, one stalking, one harassment, with all the way up to the felony thing, and then the interference with the court, another thing, nuisance or whatever it was. They could have charged all that shit in like 4 charges, and it would have cost like $10,000-$12,000 for a defense, and been easier to defend against, or more fair to defend against, instead of 20 charges from all over the place. Which is the same reason why, I can't even tell you what they said in court was the exact point or act that Myers took that was a violation of probation. Like, was it the video with the Shannon Walker astronaut and or athlete thing? Well, we didn't have to watch a video on none of that shit. We could have just seen the screenshot, entered that in evidence. But we did watch some sections on that. And then, most of it is just Matt Walker testifying. And it's like, well, what is, he doesn't have any first-hand information in anything. He's just testifying because, boy, is he a great freaking witness for the prosecution, being a prosecutor, which, again, is a parent standard thing. Okay, and this is where I'm going to get some kickback on, but let's see, where is the latest copy? Revised one. I'm opening this up in a different app, so I can jump around without losing where I'm at on the other one. It's the same exact file, but what I'm doing is I'm going here to exhibits, and I'm going to jump to this motion for examination of defendant's competency. This was filed by, you'll never guess, Matthew A. Walker. And just to prove that, um, if you go down here to the signature line, blah, blah, blah. And boy, this thing is long and drawn out. And there's his name. By Matthew A. Walker, attorney for the state, mailed, emailed, and or delivered, blah, blah, blah. Okay, so I'm not going to read hardly any of this. The only point is that it exists and how this played out in a series of events. So, this is a motion to transfer a criminal case out of Tucson City Court to, and these are the two cases, and that is the O'Reilly Auto Parts. I guess we now know which one that one was. And I guess it's both O'Reilly Auto Parts. I thought the other one was the Boeing, but I guess I was wrong on that. So you can see that's a copy and blah, blah, blah. So it's a motion for examination of defendant's competency pursuant to Arizona Rules of Criminal Procedure 11.2. And basically all you need to know is it says that we want to transfer it, and then we want to evaluate this guy mentally for competency. And the reason why this matters is because he's acting on behalf of the state. And so this is all known. So the series of events, and let's see, what day was this? I believe this was in sometime in 2024. October 8th, 2024. So the end of 2024, and the felony cases were, I want to say March, June. I'd have to look that up to be sure. But the point being, why didn't they proceed with this competency once they had him on felonies, right? So misdemeanors, we need to drag all that out, maybe lock him up for evaluation and treatment, and the way I see it, abuse the mental health process. But then once you get him on felonies, right, then we don't need to do any of that, right? And that's what this section here is saying, right? So on the appearance of justice, and then that really calls into a lot of things in question, because you have cases like Robinson here that says once you have this idea that he might not be competent, you can't proceed to cases. You have to do that evaluation and on the record, which, now it's been like a year later, so I don't know if they can even recover from this one, if it somehow did go back to that. But I do point out that it was a prosecutor's own sworn good faith representation to a court based on months of direct interaction. I'm not saying I agree with Walker or the state. I'm just saying, why the discrepancy? Blah, blah, blah. And then we have some more about that. And you guys can read that if you want to. You can also dance if you want to. Anyways, okay, so here I'm setting up what's called the appearance standard, or regarded as standard under Americans with Disabilities Act Title II. So you can't discriminate, and you don't actually have to be disabled. All it has to do is have the appearance of discrimination against the protected class, and it's a violation of law. It's unlawful. Which this is not. I'm not suing for damages. I don't have a claim there. But as a disabled person, I very much do have an interest here. Blah, 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 blah. And then I go into, basically talking about how a lot of the stuff they claim Myers did makes him dangerous, but they're always leaving out how they close the gap from allegation to conclusion. And what I'm laying out here is the allegation that he's mentally ill, or the treating of him as if he were mentally ill, is the onus. And so that's discriminatory. It's and Walker said that in his testimony. He basically said verbatim, I don't know Lane Myers. I don't know what he's capable of. Well, that's true of anybody you don't know. But if you add this history with the competency, now you have this implicit, well, the reason why he thinks that is because he thinks Lane Myers is crazy, which would be like the non-scientific term for bipolar or something. And then I point out that none of what he's saying in court has anything to do with what he's actually doing. So he acts like this guy is crazy and a loose cannon and dangerous, but at the same time, he files a petition to aggravate him. That doesn't seem like, to me, a person that's fearful of another. You don't agitate somebody. We're going to move right along. Right along. So we set the standard. A guilty plea produces none of that. No factual findings on the theory's validity, no appellate review, no reasoned opinion by anyone to rely on or challenge. Yet the record here reflects that this matter's outcome reached without the underlying no legitimate purpose theory ever being tested, as set in section VH above has been put forward publicly by Walker's own petition. And the state can't have it both ways. This outcome's been tested, but it wasn't really tested. And now we're going to try to change the rules of the court. Blah, 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 blah. So I definitely bring this up. YouTube is a new phenomenon, and the stalking, harassment, and all that predates it. And it predates social media. And so what this case does is it sets up the real legal standard, even though it's not being tested. Blah, blah, blah. Then I talk about how the state isn't trying to regulate YouTube and stuff, even though it can, because it regulates pornography sites. There's other states passing laws where the damn operating system has to incorporate um, age verification. Not just the app or the website, the whole operating system now has to do it. So, they have that kind of jurisdiction and pull, but they can't, regulate this YouTube stuff without, just going after Lane Myers. Blah, blah, blah. You guys can read that if you want the details. I don't really have the voice. And then I talk about how, like Hustler Magazine versus Faldwell, the court has protected really, really bad speech. You have the God hates fags, going to uh, um, like funerals and saying that crap. And you have the Faldwell, proposing that the religious guy fornicated with his mother in an outhouse back in the time where that really would have been a thing. And then, it was in a magazine, so it really, everybody saw it. Um, I don't know, I think I'm about closing up. Um, re- Relief requested, accept jurisdiction, expedite consideration, vacate the court's order restricting audio recordings, provide video recordings, declare disruptive activity something in the courthouse, in the courtroom. Declare that a presence of a victim who has not spoken, blah, 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 blah. Declare that the petitioner's request is governed. Declare that the administrative order is outside of the duly delegated authority. Consider it under the ADA. Find cumulative pattern, vacate, not being able to intervene, and grant any such relief as this court deems just. It says filed yesterday, but it was actually filed today because I screwed up. I forgot this all important certificate of compliance, which that's funny. It's like a different. Oh well. And then we have this page I forgot, and then we have the exhibits. So that's the minute entry. Blah blah blah. Huh. This is the administrative order. Now, this has to do with the courthouse itself. And what I was talking about earlier is this section here. May be held in contempt of court and may be charged with criminal offenses. This is dangerous logic here, because any other court in Pima County that reads this can no longer be objective. Oh, well, this order says it's disorderly conduct right here. Right? It's an open and closed court case. That right there is very, very dangerous. Here's like the sign, and again, it's got all that language. This is the Supreme Court delegating the authority. So this is all that the Supreme Court said. This is all that Pima County said. So we got one page that turned into three. But more importantly, it just says uh-oh. I think this is the wrong. I think that was the wrong order. No. Anyways, it sets up it sets up basically that the court will set up rules for the safety and security. Um, and it's long-winded because here's the order denying my amicus brief. And they're pointing out that a rule doesn't exist, which is funny because I pointed out a rule doesn't exist, and I guess they went with what I pointed out. Here is the motion for competency, and basically, I don't agree with his assertions here or conclusions or any of that. I'm just saying it does exist, and it's awfully telling that they would say that this is mental illness and needs the competency hearing, and then we get the felony charges, and then all of a sudden we don't need to do that because, well, we got him now. We went from misdemeanor to felony, so we don't want to mess up that felony conviction with any competency stuff. And these are the exhibits. And there's actually quite a bit here if anybody wants to pause and look at, what he was saying and the narrations and blah, 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 blah. And there is some pretrial order. Defendant granted, time is excluded, trial. So he wanted disclosure statements. Probably the bond conditions modified. Accepting waiver of the, and this is I don't know, some sort of fate. I don't know. These exhibits are for the competency thing. Now you're dumb, blah blah blah, is trying to delete comments. What is that? To Matthew Walker. Blah blah. Present by Zoom. Pre-trial. Yeah, and I bet you that went all great. Yeah, language. Seriously though, if cussing makes you mentally ill and incompetent, there's a lot of incompetent people. Look, they use Outlook. Blah blah blah. Some more exhibits. Da da da. Lane Myers talking on YouTube. See, they can get you on it. Get you on anything nowadays. Deposition. Then we have the charges in one case. We have the screenshot of who was Lane Myers' victim. So I even spelled it wrong and everything. And it still says her name. And then here's her page on University of Arizona. And just some search results. And then you have the table of authorities. So if you want to jump to Drope versus the... hopefully... Oh, man. I wonder if the page index has got off. Oh well, I didn't even need to include a table of authorities, so it was off by 2 pages. But that was just a courtesy anyways. So, there we have it. Let's see what we have for the hate room. So, let's see. Do we have any deleted comments? So, we got Plummet. We already talked about that. Greg says free Lane Myers. Says it's pronounced Lewski. I think he might be joking. Loonski. Wowski. Whatever. Evening guys from T-Man. Your friend Joe, #1. Thank you for covering this. Kicking and screaming. Why won't this scroll? Wow, this has got like the responsiveness of who knows what here. Is it because this is no? So then I have the link to the rules forum. They're discriminating based on association to the public. Judy's. Yeah. I'm sure she's gonna say it's all different. T-Man apparently retracted some comment. Boy, I don't know why this webpage is. I guess we're gonna start from here. Yep, 13/29/21 is 30 years old. Using is the court documents and legally sent emails and phone calls. How can they regulate what is allowed in court and happens millions of times a day without state regulation? Ha ha ha. Jason's whack. I hope that there's no reference to me. So you can sue them for threatening your interests. I'm not suing them, it's a special action. So because authority delegates down, I'm bringing the delegated authority up through the courts and saying, hey, do you think this is right? Do you think this authority was delegated this way? That's what a special action is. It's the combination of a writ of mandamus, writ of prohibition, and writ of something else. I forgot. Can't think of right now. Yes, keep scrolling through, please. That's when Mackenzie left Lane a comment, and he read her rights. Huh. And then Matt told Walker her victim is trying to contact him, and then she shows up in court for the pretrial as a victim, and the case gets dismissed because the state didn't have the star witness. That's crazy. Putting some Chinese words in there. Well, and that pretty much concludes this anyways. So, we have the end.